For this video, we are going to talk about the crimes of treason, conspiracy and proposal to commit treason, and misprision of treason. These are found in Articles 114 to 116, respectively, in Title 1 on crimes against the national security and the law of nations of the Revised Penal Code, as amended. Let's start with Article 114 on treason. Article 114, Treason. Any Filipino citizen who levies war against the Philippines or adheres to her enemies, giving them aid or comfort within the Philippines or elsewhere, shall be punished by reclusion perpetua to death and shall pay a fine not to exceed 4 million pesos. No person shall be convicted of treason unless on the testimony of 2 witnesses at least to the same overt act or on confession of the accused in open court. Likewise, an alien residing in the Philippines who commits acts of treason as defined in paragraph 1 of this article shall be punished by reclusion temporal to death and shall pay a fine not to exceed 4 million pesos. So, this is the specific provision on the crime of treason as found in the Revised Penal Code as amended. What are the elements of Article 114 on treason? First element, take note that the offender must be a Filipino citizen or the offender can also be a resident alien. Second, there is a war in which the Philippines is involved. Third, the offender either levies war against the government or adheres to the enemies, giving them aid or comfort. So, let us discuss each of these elements. How do we define treason in general? Treason in general is a breach of allegiance to a government committed by a person who owes allegiance to it. So, a citizen is a primary and classic example of a person who owes allegiance to a government, and even resident aliens to some extent, no? Because they seek the protection of the government of the country in which they are residing, even though temporarily. Now, when you say allegiance, allegiance is the obligation of fidelity and obedience which the individual owes to the government in return for the protection he receives. This was the pronouncement of the Supreme Court in Laurel versus Misa. In other words, it is the obedience of an individual to the laws of the government or sovereign in which he resides or is a citizen. In the dictionary, allegiance means loyalty or commitment of a subordinate to a superior or of an individual to a group or to a cause. Now, when you say offenders in treason, the first question that should come to your mind is who are the offenders in treason and what kind of allegiance do they owe the government or the sovereign? For the Filipino citizen who is one of the offenders in treason, a Filipino citizen owes absolute and permanent allegiance to the government of the country of which he is a citizen. So a Filipino citizen owes absolute and permanent allegiance to the government of the Republic of the Philippines. On the other hand, a resident alien owes qualified and temporary allegiance only, okay, to the government of the country in which they are currently residing. Why do they owe only temporary allegiance? They owe only temporary allegiance because an alien owes permanent allegiance to his own country. So when you say alien, when you speak about an alien, bear in mind that he owes permanent allegiance to his own country or to the country of his citizenship. And in the case of an alien who resides in the Philippines, he only owes what? Qualified and temporary allegiance. Now, the term resident alien is not defined or described in the revised penal code. But for purposes of payment of income tax, an alien who is present in the Philippines for at least 2 years is a resident alien, whereas an alien who stays in the Philippines for less than 2 years is considered a non-resident alien. So, since there is no definition given by the revised penal code of what a resident alien is, or for how many years should an alien reside in the Philippines for him to be called a resident alien, then we can probably apply or use the definition of resident alien in our tax laws, such that under our tax laws, a resident alien, to repeat, is one who is present or residing in the Philippines for at least 2 years. So that should be the determining period to consider an alien a resident alien for purposes of applying Article 114 of the revised penal code on treason. Now, treason as a crime can only be committed in times of war. It cannot be committed in time of peace. The term war here means a war against other countries or against other states in which the Philippines is involved. It doesn't refer to domestic wars or domestic conflicts like the war waged by our government against the CPP and PA. Moreover, under Article 6, Section 23, Paragraph 1 of the 1987 Constitution, Congress, by a vote of two-thirds of both houses in joint session assembled, voting separately, shall have the sole power to declare the existence of a state of war. It is therefore clear from this provision that of the three branches of government, it is only the legislative branch, represented by Congress, composed of the House of Representatives and the Senate, that has the sole power to declare the existence of a state of war. The question is, should there be first a declaration of the existence of a state of war before Article 114 on treason is to be made applicable? The answer is it depends, because there are two ways of committing treason. The first way of committing treason is by levying war against the government, and the second way of committing treason is by adhering to the enemies of the Philippines, giving them aid or comfort. Now, with respect to the first way of committing treason, I am referring to by levying war against the government. It would seem from the opinions of renowned authors on the subject that it does not need the declaration by Congress of the existence of a state of war before the crime of treason under this mode becomes applicable. But with respect to the second mode or the second way of committing treason, it would also seem that there must first be a declaration of the existence of a state of war by Congress before a person can be charged of adhering to the enemies of the Philippines, giving them aid or comfort. Meaning to say, there must first be a declaration of a state of war by Congress before a person can be charged under the second mode or second way of committing treason. Let us discuss the first mode or first way of committing treason, which is the act of levying war against the government. What are the elements of levying war against the government? Number one, there must be an actual assembling of men. And number two, the actual assembling of men must be for the purpose of executing a treasonable design by force. When you say actual assembling of men, it means that there must be a physical gathering of persons, at least by a band. No? The gathering must be at least by a band. When you say band, if we are to adopt the definition of band in the crime of robbery, a band is a group of more than three armed malefactors. So, to repeat, actual assembling of men, or in other words, actual assembling of men means that there must be a physical gathering of more than three armed malefactors. And once there is such a gathering, all those who performed any part, however minute or however remote from the scene of the action, and who are actually leagued in the general conspiracy, are to be considered as traitors. Of course, we are just talking here about theory. There must be evidence to establish that this or that person participated in the actual assembling of men for the purpose of executing a treasonable design by force. Now, the term treasonable design by force means to overthrow and destroy the duly established government. The duly established government I am talking about here is the government of the country of the person committing the crime of treason. So, when you say treasonable design by force, the purpose of the traitor must be to overthrow his own government and not merely to resist a particular statute or law or to attack or repel a particular government official or government branch or institution. Meaning to say, his aim must be to overthrow the entire government, similar to what we will discuss in our future video or videos, similar to rebellion. No? It's a public uprising for the purpose of overthrowing the government. It's not necessary that those attempting to overthrow the government by force of arms should have the apparent power to succeed in their treasonous design. This was decided in the case of US versus Lagnason. What is important is the act of the offenders or traitors in levying war against the government for the purpose of executing a treasonable design by force. No? The actual assembling of men for the purpose of executing a treasonable design by force. That is enough to constitute the crime of treason. Success, therefore, is not an element. As a matter of fact, if the traitors or the offenders succeed in overthrowing the government, then there is no more treason to speak of, since they have already what? Overthrown the government. Who will prosecute them? That is the logic behind this decision of the Supreme Court. As I mentioned a while ago, the term levying war against the government is akin to a rebellion. Rebellion as a crime or as defined and penalized in Article 134 of the Revised Penal Code. The only difference between treason and rebellion is that in treason, the levying of war must be in collaboration of a foreign enemy or with the intention of helping a foreign enemy. The enemy here I am referring to is the foreign country or the foreign state in which there is a war in which the Philippines is involved. Now let's go to the second mode of or second way of committing the crime of treason, which is adhering to the enemy, giving them aid or comfort. So the elements are number one, there must be adherence to the enemy. And number two, the offender gives aid or comfort to the enemy. Take note that adherence alone without giving aid or comfort, or vice versa, meaning to say, giving aid or comfort without adherence is not sufficient to constitute treason, or is not sufficient for purposes of committing the second mode of committing treason. So there must be what? Both adherence to the enemy and giving the enemy aid or comfort. Now, there is adherence to the enemy when a citizen intellectually or emotionally favors the enemy and harbors sympathies or convictions disloyal to his country's policy or interest, as ruled in the case of Kramer versus US. But as I said a while ago, adherence alone without giving the enemy aid or comfort does not constitute treason. For example, in one case, the fact that the accused had friendly relations with the Japanese during the war, like openly revealing himself sympathetic to the cause of the enemy and also believing in the invincibility of the Japanese armed forces, does not constitute in itself treasonable act as defined by law, because adherence to the enemy is not enough. It must be coupled with giving the enemy aid or comfort. So the two conditions must concur: adherence to the enemy, giving the enemy aid or comfort. Now, aid or comfort means an act which strengthens or tends to strengthen the enemy in its conduct of war against the traitor's country, or it can be an act which weakens or tends to weaken the power of the traitor's country to resist or attack the enemy. There must be a deed or physical activity, such as furnishing the enemy with arms, troops, supplies, information, or means of transportation. It is not essential that the effort to aid would be successful, provided overt acts are done. No, there must be a physical deed or activity, which, if successful, would advance the interest of the enemy. Now, the aid or comfort given to the enemy must be after the declaration of war between the countries. This was the question I posed a while ago when I said, should there be first a declaration by Congress of the existence of a state of war before the crime of treason under Article 114 be made applicable? And the answer is, it depends. It depends on the mode or way of committing treason, because if the mode of committing treason is levying war against the government, then it would seem that a declaration of the existence of a state of war is not necessary. But when you talk about the second mode, adhering to the enemy, giving the enemy aid or comfort, there should first be a declaration of war between the countries. Okay? The term enemies refers to the foreign power in a state of hostility with the traitor's country. The traitor I'm talking here is the offender committing the crime of treason. He's called a traitor. In levying war, as I said, no declaration of war is necessary. Now, if in the course of levying war, or in the course of adhering to the enemy and giving aid or comfort to the enemy, common crimes are thereby committed in furtherance of the treasonous acts, what will be the ruling, or what will be the effect? These common crimes will be deemed absorbed as an element in treason. They will not be regarded as separate crimes or as complex with treason. So for example, if during the Japanese time, X killed his fellow Filipino Y to support the Japanese army in subjugating a particular barrio, that is what? What X did to Y, his killing of Y, constitutes murder. But since it was committed by X in furtherance of his treasonous act of supporting or giving aid or comfort to the invading Japanese soldiers, what could have been a separate crime or charge of murder will now be deemed absorbed as an element in treason. Meaning to say there is only one crime committed, that is treason. It will not be the murder, the killing of Y in that example will not be treated as a separate crime of murder, nor will it be complex with treason. This is similar to rebellion. Okay? So, common crimes committed in furtherance of the rebellion will not be treated as separate crimes or will not be complex with rebellion. They will be absorbed as an element in rebellion. Also take note of this. If the offender is a Filipino citizen, treason can be committed even outside the Philippines. So, for example, if the Filipino citizen is in another country and he commits treasonous acts, no, he commits any of the modes of committing treason as defined in Article 114, even if the crime was committed there in that other country, which should be beyond, which is already beyond the territorial jurisdiction of the Philippines, still he can be charged for the crime of treason for the simple reason that he is a Filipino citizen. But with respect to a resident alien, he can only commit the crime of treason while he is in the Philippines, or he commits the said crime while he is in our country. Because if he commits any of the treasonous acts when he is no longer a resident, meaning he is already in another country or in his own country, he can no longer be made liable for treason because he is no longer a resident alien. Also, treason is a continuous offense as it can be committed by a single act, by a series of acts, not only in a single time but in different times. They constitute only a single crime or a single offense of treason. There will be no separate counts or multiple counts of treason. Only one crime of treason is to be charged against the traitor or the offender. Now, what are the ways of proving treason? There are two ways of proving treason. One is by the testimony of two witnesses to the same overt act, or the so-called two-witness rule. Or second, treason can be proved by the confession by the accused himself, no, by the traitor himself in open court when the traitor is charged in court of treason and he later confesses to the crime. This means that treason cannot be proved by circumstantial evidence or even by the extrajudicial confession of the accused. What if, Fiscal, there is only one witness who testifies that he actually saw the overt act of the accused in committing treason? That will not suffice because, like what I said, there must be at least two witnesses to the same overt act. What if, Fiscal, the offender executes an affidavit with the assistance of the lawyer of his choice? No one forced him or coerced him in stating in his affidavit confessing to the crime. Still, it will not be enough because it requires only it needs the testimony of at least two witnesses or by the confession of the accused himself in open court. If he wants to confess, he must confess the crime in open court, not execute an affidavit or not make in an extrajudicial confession for that matter, even if it is a valid extrajudicial confession. Example of the two-witness rule. X saw Y doing guard duty in a Japanese garrison one night. Z also saw Y doing guard duty in said garrison on the said night. Here, the two witnesses X and Y are testifying to the same overt act that they saw, rather X and Z, no? X and Z testifying to the same overt act that they saw Y doing guard duty in a Japanese garrison on the same night, or referring to the same date and time. Another example, X heard a gun report, okay, and saw a smoking gun in the hand of Y, and he likewise saw the victim fall. Z likewise saw Y raise and point the gun and see a puff of smoke from the said gun. Now, while X's and Z's testimonies may not be outrightly identical, if you notice, no, X heard a gun report and saw a smoking gun, whereas Z merely saw the offender raise and point the gun, but also saw a puff of smoke from it. They are not identical, but they still refer to the same overt act, and that will be accepted for purposes of the two-witness rule. The two-witness rule applies to the two modes of committing treason. Again, what are the two modes of committing treason? One is by levying war against the government. No? Levying war against the government is the actual assembling of men for the purpose of executing a treasonable design by force. The other mode of committing treason is adhering to the enemy, giving the enemy aid and comfort. So, take note that the two-witness rule applies, to repeat, for the two modes of committing treason. However, with respect to the second mode of committing treason, it is only with respect to the element of giving the enemy aid and comfort that the two-witness rule applies. With respect to adherence to the enemy, the testimony of at least one witness is sufficient. What are the defenses in treason? There are two recognized defenses in treason. When you say defenses in treason, this is the defense that the person accused of treason would invoke in court to absolve him of criminal liability. So, for example, X is charged of the crime of treason, and X invokes the defense of duress or uncontrollable fear. Even if there are two witnesses who would testify that they saw X giving the enemy aid and comfort, referring to the same overt act, but if X is able to prove that he was under duress when he gave aid and comfort to the enemy, or he was in a state of uncontrollable fear of his life when he gave the enemy aid and comfort. Why? Because the enemy would kill him if he did not give them aid and comfort. If he is able to raise these defenses and he is able to prove these defenses in court, then he would be absolved of criminal liability. Another recognized defense is the defense of lawful obedience to a de facto government. History has recognized that during the Japanese occupation during the Second World War, the Japanese imperial forces in the Philippines established a Japanese republic run by Filipinos. So these Filipinos who were forced, no, or who were obliged to run the affairs of the country under the control of the Japanese imperial forces, they were not deemed to commit a treasonous act because they were just what? In lawful obedience to a de facto government. What about the defense of suspended allegiance and change of sovereignty? Will that be accepted as a defense? The answer is in the negative. Why? Because there is no such thing as suspended allegiance. There is no such thing as change of sovereignty. A citizen owes an absolute and permanent allegiance instead to his government, regardless of the situation of the legitimate government at that time, whether that legitimate government is functioning or in exile. It doesn't matter. In the eyes of the law, a citizen owes a permanent allegiance to his legitimate government. And with respect to sovereignty, the sovereignty of the legitimate government is not transferred to the enemy by the mere occupation of the enemy. And the rules of international law recognize the subsistence or the continued existence of sovereignty of the legitimate government, regardless of the fact that the territory of the legitimate government is being occupied by the military forces of the enemy. Because what is suspended with respect to sovereignty is only the exercise of the rights of sovereignty, but not the sovereignty itself. So again, the defense of suspended allegiance or change of sovereignty will not be accepted as defenses whenever an offender is charged in court of treason. Let's now go to Article 115, Conspiracy and Proposal to Commit Treason. Article 115, Conspiracy and Proposal to Commit Treason. Penalty. The conspiracy and proposal to commit the crime of treason shall be punished respectively by prisión mayor and a fine not exceeding 2 million pesos, and prisión correccional and a fine not exceeding 1 million pesos. So the penalty for conspiracy to commit treason is higher, whereas the penalty of the crime of proposal to commit treason is lower by 1 degree. Remember that as a general rule, the mere conspiracy and proposal to commit a felony is not punishable as a rule. Okay? Article 8. But in Article 115, the mere conspiracy to commit treason or the mere proposal to commit treason is already a felony. And the two-witness rule does not apply to conspiracy or proposal to commit treason. So, what again is the two-witness rule? The two-witness rule requires that there must be at least two witnesses who will testify to the same overt act of treason. But this two-witness rule applies only to the crime of treason itself, not in the crime of conspiracy or proposal to commit the crime of treason. What about misprision of treason in Article 116? Article 116, Misprision of Treason. Every person owing allegiance to the government without being a foreigner and having knowledge of any conspiracy against them, conceals or does not disclose and make known the same as soon as possible to the governor or fiscal of the province or the mayor or fiscal of the city in which he resides, as the case may be, shall be punished as an accessory to the crime of treason. So, what are the elements of misprision of treason? Number 1, the offender owes allegiance to the government and not a foreigner. Okay, meaning to say, the offender here is not a foreigner. The offender here is a Filipino citizen. Number 2, he has knowledge of any conspiracy, the conspiracy to commit treason. And number 3, the offender conceals or does not disclose and make known the same as soon as possible to the governor or fiscal of the province or the mayor or fiscal of the city in which he resides. So, the article is specific, no? The disclosure must be made to the governor or to the fiscal and not with respect to any other public official, not even to the chief of police, no? The disclosure, the obligation to disclose must be made to the governor or fiscal of the province or the mayor or fiscal of the city in which the offender resides. Take note that the article does not apply when the crime of treason is already committed and the accused does not report its commission to the proper authority. What is punished in Article 116 is knowledge of any conspiracy to commit treason. and he fails to report the same to the proper authority. He will not be punished if he fails to report a treason which has already been committed by another person. Again, what is punished in misprision of treason is the failure to report his knowledge of any conspiracy to commit treason. The offender in misprision of treason is punished as an accessory to the crime of treason as explicitly or expressly stated in Article 116. But he is also a principal in the crime of misprision of treason itself. So the offender here assumes a dual role. No? He is deemed as an accessory in the crime of treason in Article 114, but he is also deemed as a principal in the crime of misprision of treason itself. In such a case, therefore, Article 20, if you still remember, Article 20 on exemption from criminal liability of certain accessories, it will not apply to him because even if the offender is related to the persons in conspiracy against the government, he will not be considered as an accessory because of his dual role or of the nature of his being a principal in the crime of misprision of treason itself in Article 116. So that ends our discussion on the three crimes, no? Treason, conspiracy and proposal to commit treason, and misprision of treason.